the, the goals for this particular meeting and get started, because we have a robust agenda. So
we certainly do. Karen, thank you, and thank you for being our facilitator. We welcome everyone that's joined in or maybe watching on the Attorney General's YouTube channel. So this is our second meeting. This is work group number 3. And work group number 3 has 5 main categories that we have been asked to look into, and it can be expanded. But the first one we looked into what we should do about equity training in our criminal justice system. And I think we came up with a consensus at the end of our first meeting that we all believe there should be a robust, continuing racial equity training for everyone in the court system, including judges, DAs, public defenders, criminal defense attorneys, magistrates, probation, and parole officers. And that became our recommendation out of our first meeting. This meeting, we have a lot to tackle because they're broad issues, and we will try to dive down into them, but it is charging. So the role of the prosecutor in charging. And then also criminalization. Are we over criminalizing too many of our statutes or too many of our city ordinances? Or we're going to look at that. And we have some great speakers, and we're going to welcome them all. I would like to make sure that everyone knows this work group has 5 members on it. And Tara Callahan is with us. And Tara is the Executive Director of Conservatives for Criminal Justice Reform. Tara, we're glad you're here. We're glad you're on camera now. Senator Mustafa Muhammad from Charlotte is in his first term in the Senate, in the General Assembly. More importantly, he was a public defender and an advocate for the Council for Children's Rights in Charlotte. So Senator, thank you very much. We have County Commissioner Ronnie Smith with us from Robersonville. And Commissioner Smith is also the president-elect of the North Carolina Association of County Commissioners. Very much need him and happy to see him today. Also, District Attorney Jim Woodall.
Let's go with Jim.
Jim, Orange Chatham County's been the prosecutor there for 15 years. He was an assistant DA before that. He's been very involved in looking into racial equity and changes in our criminal justice system. And myself, I'm Marcia Morey, District Court Judge for 18 years in Durham, and now I'm in my second term as a representative at the State House. I'd like to acknowledge we have our co-chairs that are listening in, Attorney General Josh Stein and Justice Anita Earls, who are the co-chairs of the task force that were appointed by Governor Cooper to chair this. The governor's staff, Natalia Batella, is our liaison, and she is here. And we have facilitators on today with us is Karen Dreyer. So, and we thank Ashanta Preddy for the minutes of our first meeting on August the 5th. I hope everyone has been able to review those minutes. I don't think it's our protocol to vote on them, but if you have any additions or corrections, please let us know. She did a great job with those minutes and we really appreciate it. So today, we are first going to hear, and I'm going to have the lead on this, Jim Woodall, to take over the prosecution and the charging. It may blend in a little to our statutes and criminalization. And then we have some other dynamic speakers after District Attorney Woodall. So Jim, please take it over.
Okay, and first let me see if I can share this. And is that showing up on your screens? It's not? How about now? Is it sharing?
Yes.
It is? Okay. And real quickly, I was an assistant DA for about 15 years prior to coming to Orange and Chatham County. I did some per diem work down in Wayne, Goldsboro, and Lenoir County, and I've been the elected DA for 16 years. This is a broad topic, and we can't even begin to scratch the surface today, but I'll try to introduce us to the topic. You know, I've titled this prosecutorial decision making, although we know other people, other actors also make some of these decisions. And I'll try to touch on over criminalization, charging decisions, and prosecutorial discretion. And I wanted to start just thinking a little bit about over criminalization and decriminalization. I think everybody knows over the years, in my opinion, we've criminalized too many types of conduct in this state. And I think one of the things that's happened, we have too many case-specific crimes. Over the years, we've had cases here in our district that a legislator or other person has taken an interest in, and then there's a statute written to cover that really specific fact pattern. And I don't think that's a good idea. And we need to look at that. I think the legislature really needs to reevaluate the entire criminal code in North Carolina. I know that's a huge undertaking, but I think it's time. Something we've all talked a lot about, ordinance violations, traffic offenses could be shifted out of the criminal justice system. Low-level offenses, what we sometimes refer to, or at least we refer to some of them as nuisance offenses, should be reevaluated by local boards and the legislature. And I think both Jessica and Amisha may talk a little bit about that. You know, although decriminalizing isn't a decision that's made directly by prosecutors, I think where we can help is being supportive of decriminalization where we think it's good public policy. And I do think that's a little bit tougher for some prosecutors than others. Where I am in Chatham and Orange counties, I can advocate for a lot of things that a prosecutor in the eastern part of the state probably can't advocate for, or in the western part of the state, or at least they couldn't advocate for it and remain a prosecutor, an elected DA, very long. So I think we have to keep that in mind. I think there's also something important to think about, that groups like this task force, we can make policy recommendations to deprioritize certain offenses, and that can help local leaders kind of make decisions that may otherwise be tough for them. We talk locally about low-hanging fruit and some of the things we can do to make an immediate impact. It's not always something that is easy to do politically, and it may be more difficult to do, as I said, in different parts of the state. But I think when you've got groups like this task force, if we can recommend some best practices, that can help local boards, county commissioners, and others advocate a little bit harder when they can lean on us a little bit in our recommendations. Charging decisions. In North Carolina, as far as prosecutors go, there's not a lot of formal guidance on how we make charging decisions. The closest thing we have is the bar rule 3.8. And literally what it says is the prosecutor in a criminal case shall refrain from prosecuting a charge that the prosecutor knows is not supported by probable cause. That is really what we have in North Carolina to lead us on how to make charging decisions. We can find other resources, but that's one of the few rules or recommendations we have. There are some selected ABA standards, functions of prosecutors that I think are very helpful. And there are also books that have been written on the subject, but I think the ABA standards are very helpful. Shay Denning wrote a School of Government blog post a few years ago about 5 ethics rules every prosecutor should know. I also think that's something that could help all the state's prosecutors if they just take a look at that. One of the things that I think everybody here probably knows, but I just remind everybody, most initial charging decisions are not made by prosecutors. I mean, we have citizens warrants that they go to a magistrate, they swear out, as we say, a warrant. Here in our district, that's a very small percentage of the cases. It's around 5 to 6%. So it's not a big percentage, but that may be different in other parts of the state. The bulk of the charges, the great majority, are initiated by law enforcement. And in most situations, they don't consult with the prosecutor. They do that based on what they feel is probable cause, that they have probable cause that an offense has occurred. They go to a magistrate, they seek a warrant or some other type of process. And that's for both misdemeanors and felonies. Here in our district, law enforcement initiated charges account for well over 90% of all the charges we see. So I just want to point out that prosecutors do not initiate most of the charges. As we all know, what we do, we decide whether the charges go forward, whether they actually get prosecuted. I do want us to think about pre-charge diversion and deflection. I think that is part of the function as a prosecutor. Most of you probably know, and I know that Marcia actually helped start the program in Durham for their pre-charge diversion program. We have one here. It's not based on the offender's age. It's not based on their criminal record. Everyone is eligible, but it is initiated by law enforcement. Law enforcement officers have the discretion. We have a list of offenses, about 20 offenses, and rather than charging an individual, law enforcement has the option to refer them to our pre-arrest diversion program. If they make contact and they follow through, there's never a charge. If they fail to follow through, the law enforcement officer has the discretion to go back and take out that charge. We also use deflection here, which is slightly different. The best example of that is the Chapel Hill Police Department has a crisis unit. They've had it since 1976. Everyone who's employed there is a licensed social worker. And so there are calls that Chapel Hill gets, for instance, that would normally in a lot of locations end up in the criminal system, but the social workers with the police department take over the situation and it never gets into the criminal system. There's never a charge. And I think the idea of deflection is gaining ground in a lot of places, but I think those two things, pre-charge diversion and deflections, can really keep a lot of things out of the court system and definitely keep some things out of the court system that don't need to be here. Some situations where there are really mental health issues, those kinds of things that the court system's not equipped to handle in any event. But, you know, once we get past the law enforcement initiated charges, something isn't deferred, then the question is to prosecute or not to prosecute. And in North Carolina, really, the guidance we have is, the question is, does probable cause exist? Is it more likely than not that a particular crime or crimes were committed and that the suspect committed the crime or crimes? I mean, if there's probable cause, you can bring a charge. And as a prosecutor, you're not violating any ethical standard by pursuing that charge if you genuinely believe that probable cause exists. I think most prosecutors, or hopefully most prosecutors, have at least one other step that they look at before they decide to go forward with a charge, and that is there sufficient evidence to support a verdict of guilty? You know, that requires proof beyond a reasonable doubt. And I think if you go to that second requirement, you ask yourself as a prosecutor, is there sufficient evidence to support a guilty verdict? It greatly reduces the number of charges that you move forward with. I think one of the problems we have at the law enforcement level, they really look at probable cause by and large. They don't consider the second step. I think you need to go a lot further than that second step. But I think at a minimum that this is what prosecutors should be looking at. And it's certainly what we try to look at. I think once you meet those two requirements, probable cause, you have enough evidence that you believe you could obtain a conviction, I think that's where discretion really starts to come in. There's certainly discretion earlier, but at this point, I think prosecutorial discretion comes into play. Is the decision to charge or to prosecute in the best interest of justice? I think that's the key question. And I think there are a lot of things to consider as a prosecutor to determine or try to determine whether the answer to that question is yes, it is in the best interest of justice. And I'm just listing a few things. This list could be a lot longer, but things that prosecutors should consider, at least things I consider. I think it's important as a prosecutor to be personally convinced that based on the evidence, you can prove guilt beyond a reasonable doubt. I think that's a little different idea than just thinking, well, I have enough evidence that someone could be found guilty. You should believe in your heart that the person is guilty and that you have enough evidence to prove guilt. And then I think that goes into my next point. You need to look at your experience as a prosecutor, and is it reasonable to expect a conviction based on the admissible evidence? And that's another level of inquiry on your part or consideration, because just because you have the evidence that you could convict, you may know that in your jurisdiction, maybe it's because of the makeup of your jury pools, that you're very, very unlikely to convict. And I tell all my prosecutors, unless you think you have a reasonable likelihood of conviction, you shouldn't bring a case to trial. I don't think it's our job to just throw things up there because we could argue that there is sufficient evidence to convict. We must believe that we have a reasonable opportunity to convict. And then I think you look at things like, do the interest of your victims and perhaps witnesses favor prosecution? Are the charges and the punishments proportional to the crimes that have been committed? There are many other considerations that you should balance and that should point to prosecution. And if you do all that, you still get back to, is prosecution under all the circumstances known to the prosecutor just, proper, and equitable, which I think is just another way of saying, is it in the best interest of judgment? And even if you decide that you should move forward with a prosecution, I think you can still step back and there are some other decision points. Even so, should you consider diversion? In other words, rather than prosecuting and seeking a guilty verdict, should you try to come to an agreement with the defendant so that if they do certain things, maybe it's as in a misdemeanor case, it's community service, maybe it's getting counseling, mental health treatment, drug treatment. If they do that, can the case be dismissed? They still have a charge, but they don't have a conviction, and it can be a little bit easier to get that off their record later. You should consider, I think a lot of prosecutors, and I've been guilty of this myself, sometimes you look at the highest level charge that you can based on your fact situation. I think that as prosecutors, we need to look at that. We shouldn't always decide to go with the highest level charge. So you have to look at high level versus a lower level charge. Which should you move forward with? Another thing that I think is, it's difficult, and I think sometimes it's abused by prosecutors, and I'll include myself. I think over the years, I've probably overcharged people, seeking multiple charges, even though supported by the evidence. Was that the best thing to do in the interest of justice? And then sometimes you have cases that for one reason or another, take a larceny, that someone stole $1,100 worth of goods, and you could prove that value, but should you seek a felony prosecution, or would a misdemeanor be just as good, serve justice just as well? So I think there are lots of decision points even after the decision to prosecute is made. I think one thing that's readily available to prosecutors that if we would look at a little more often can really help us are the ABA standards. Their standard 3-4.4, discretion in filing, declining, maintaining, and dismissing criminal charges, is very good. It includes all the things I've already talked about. It actually lists a total of 24 considerations prosecutors could make or should make in certain cases. It's not an exclusive list. The ABA standards recognize the importance of prosecutorial discretion. The ABA standard gives prosecutors guidance in their exercise of discretion and encourages the use of discretion. And in the ABA standards, it's pretty clear that primarily they're trying to point prosecutors toward not charging as just the default and considering lower level offenses or fewer offenses if it's appropriate. So I think the overall philosophy of the ABA standard seems to be reduce criminal culpability, potential punishment, resulting collateral consequences while protecting public safety. And I just think they're a good starting point for any prosecutor who's trying to work their way through how you make charging decisions. And I tried to think, and I've talked to a couple of defense lawyers and other prosecutors about just some ideas that this group, and I'm sure this group will have many more ideas that we should think about to make prosecutors' charging decisions more equitable and consistent. One of the things, and we've heard this already, that I think we should really look at are controlled substance laws, the drug laws. There are just so many areas that could be revised to lessen the disparities in charging, enforcement, and in sentencing. I think looking at status offenses, habitual felons, and other habitual offenses is a place that we could decrease some disparities. You know, there's something, we hear a lot about overcharging, and there's something called horizontal overcharging, where based on one particular situation, one criminal act, you charge numerous crimes. One example of that is some drug trafficking. Someone can be charged and convicted and punished for trafficking in the same drugs, for possessing the drugs, selling the drugs, transporting the drugs. And I think some of those things we should look at, ways of reducing, combining, or eliminating these overlapping, redundant, and sometimes antiquated charges. You know, I think about in the drug trafficking, those laws are very stiff. They're mandatory minimums. And it seems like, you know, even though you may be able to prosecute for numerous offenses, a person shouldn't be punished for all those offenses. And I don't think that they normally are. But I think there are places in the law that we could make overcharging have less of an impact, even if it happens. Reducing vertical overcharging, that's the idea of charging the most serious offense. I think if prosecutors adhered a little bit more strictly to the evaluation of their admissible evidence, so they only charge what they can prove, that would do a lot to eliminate or at least reduce vertical overcharging. And I think one of the things that as prosecutors we do sometimes is we think, well, I'm going to charge a higher crime. I know I may have trouble with this higher crime. Let's say it's an armed robbery. The evidence is not clear on whether there was a weapon used or not. If the testimony comes in just right, I might prove armed robbery, but I've at least got common law. I've always thought it was better just to charge and move forward on the case you feel confident you can prove, which would be common law robbery, a lesser included, but not rely on that to overcharge.
Jim, could you just wrap up in a couple more minutes?
Sure, I'm almost finished.
All right.
I think some more detailed state guidelines and recommendations on charging decisions. The state of Washington has some really detailed guidelines that are helpful. I think one of the things we need to do is get rid of some of the antiquated and seldom used charges. I'm just going to throw this in there, and I could put public defenders in here too. I think high caseloads really lead to some problems in prosecuting. I think high caseloads lead to hasty charging decisions. I think it leads to vertical and horizontal overcharging. And I think it makes it easier. So high caseloads make it easy for a prosecutor to just decide to make a charge as the default rather than really working and looking at the evidence in the case. And this isn't a charging decision, but I think the Second Chance Act that was just passed is a great tool, and it can help us mitigate some of the problems and some of the disparities we see in the criminal justice system. And that is it.
All right. Well, thank you very, very much. Are there any, do we want to try to take a couple of questions right now, or should we just go straight ahead into our next speaker? I know we're going to have a robust time being able to have a conversation during our discussion, but I just wanted to allow if there were any just really pressing questions right now for Jim. All right, then, Representative Maury, would you introduce our next speaker?
Yes, thank you. I don't know if y'all's screen still says end of slideshow, click to exit. Does that mean, do y'all have that?
Yeah, I think Jim needs to end his screen sharing.
Okay, for some reason it's lost right now.
There you go.
Yep, I got it.
Okay. Wonderful, thank you. And Jim, we really appreciate walking through that. And through the entire, presentation, we're always thinking about this in terms of racial inequities and how are we tackling this, especially getting more equity in the racial profiles of people that we bring into court, we prosecute, and how do we correct the imbalance that we've had. So next I'd like to introduce Danny Spiegel. And Danny, Senator Mohammed asked us to have Danny speak, and we're so fortunate to have him here. Danny was a public defender and now is an assistant district attorney in Durham County under our elected DA, Satana DeBerry. He has worked as a senior policy counsel at the Justice Collaborative and Fair Punishment Project. He is a graduate of that little known Harvard Law School in 2010 with distinct honors. So Danny, we're fortunate to have you. We appreciate it, and take it from here.
Thank you so much, Representative Moray, and thank you, Senator Mohammed, for inviting me. It's an honor to be here and to participate in this vital workforce, this working group for the task force. I also have a PowerPoint that I'd like to share. I'll just pull that up. Can everyone see that? Great. So Senator Mohammed gave me a pretty wide-ranging task to think broadly about prosecutor discretion and charging decisions as DA Woodall set forth for you all, grounding it in the rules of the ethics rules as well as ABA guidelines. So I wanted to hit on three main topics. So this is a progressive prosecutor's perspective about racial equity in the courts. And again, I'm Assistant District Attorney Daniel Spiegel, and I serve under DA Satana DeBerry in Durham as co-policy counsel and also as lead of the drug and property team. So you'll see that some of my discussion is biased a little bit towards the subject area that I handle regularly, but also I serve with ADA Allison Grine to think largely about policy throughout the office. So the three main topics I wanted to talk about that I thought were most salient to this task force's work is data, thinking about data broadly. Prosecutors' offices are notorious as black boxes, where it's very difficult to get information and to understand what's going on beneath the hood. And very much related to the first topic of data is the second topic, which is plea bargaining. And Dia Woodall expertly described all of the complex decisions that go into what to charge and ultimately how a case may be resolved at trial. But I think many of us on this call are intimately familiar with the concept that the vast majority, beyond vast majority, but something like 96 to 98% of cases are resolved by plea agreement, which means that most of what district attorneys are doing from day to day is making determinations about what is a fair resolution, what is a fair negotiation in this case. And that's what I wanted to spend a lot of talking about, because I think that's one of the core functions, one of the core things that a DA's office produces is setting the stage with a charge, setting the table for what is a just charge, but also what is a just resolution. And that happens through the plea negotiation process. And finally, given that we're all brought here together, having witnessed a series of very disturbing acts of police brutality, and that in many ways is what has created this momentum, whether it's Ferguson or George Floyd or Ahmaud Arbery, that is what has brought us here today. And so I think it's very important to talk about the important role that prosecutors have in complying with Brady and Giglio, and also thinking about what is our duty as prosecutors to address police misconduct, to hold officers accountable, and to also make sure that we are not relying on dishonest police officers in attaining convictions. So firstly, to talk about data, I want to talk about racial disparities and implicit bias. As you know, as everyone on this call knows, prosecutors wield enormous discretion in terms of determining how the case is going to proceed. Of course, the officer tends to bring the initial charge, but the ultimate indictment or the ultimate plea negotiation is determined very much by the prosecutor. And how do we ensure that that discretion is being used in such a way as not to exacerbate these racial disparities? How do we check those implicit biases that we all have? So in the Durham District Attorney's Office, we have made it a priority, and this is a difficult thing to do, but to try to gather data around this fundamental task of making plea offers. So we are currently working with independent researchers at Duke, the Center for Science and Justice, to have neutral independent researchers look at our process for plea negotiation. And I think that that is one of the most key recommendations I have is to actually go through the process to look retroactively at what we are doing and think about it to determine if disparities are arising. Now, I recognize that that's not necessarily going to be possible in every jurisdiction. So even having supervisors who are attuned to these issues and have the time to engage with these questions about whether there are disparities arising in plea negotiations, reviewing those plea offers, I think is a very important thing. I'd also note as a subtopic, I think it's helpful to have an analysis of bail recommendations, pretrial release conditions. I know Professor Smith works on that extensively. And I think that Duke researchers are also looking at those recommendations, but we've focused most carefully on Superior Court plea negotiations. So I just want to give you an example on the next slide. This is kind of a little bit of our internal sausage making, but I think it's helpful to see that a lot of nitty-gritty work goes into this. It's difficult. As DA Woodall pointed out, there's very high caseloads in our work. There's very crushing kind of pressures to make sure that we are taking care of our duties to public safety and handling cases expeditiously. So this does take time, but we have a system currently in place after a year and a half of Ms. DeBerry's administration of essentially gathering our Superior Court plea offers, the drafts included, not just the final resolutions, and then turning those over to researchers to do different analyses. And that includes racial disparities. We just received our first kind of large scale feedback from the researchers, but we hope to get much deeper. And I would speak just in my task as being a supervisor, I also handle several hundred cases at a time. And knowing that these plea offers are going to get analyzed and looked at, I think there's good evidence and good studies demonstrate that that is going to be helpful in checking my own bias and looking deeply from an introspective way about why am I offering this person prison and this other individual drug treatment court. So I think that's one of the most compelling things that we can do to hold ourselves accountable. Getting more into the brass tacks, we know that there are huge disparities, as Ben Finhold has discussed in this working group, as others have discussed. We know that mass incarceration takes a different toll on different groups, different ethnicities. And so we want to think very hard in our office about where do those sentences arise. And I think one topic that's helpful to think about is the way that racial disparities can compound. We know that there are decision nodes at every point, charging, pretrial release, diversion, indictment, and ultimately a plea offer. So there's a compounding process that occurs, but certain kinds of sentencing enhancements are especially prone to that kind of compounding. So in our office, we use habitual felon very sparingly. We tend not to use it for nonviolent kinds of offenses. We essentially view that there's adequate incarceration that can be sought without having to seek that enhancement. And we're concerned about the disparate ways that can be used. And we also require supervisor approval, or in some cases, the boss's approval before instituting habitual felon indictment. Similarly, possession of firearm by felon. Now that's kind of a talismanic charge traditionally for prosecutors, in the sense that federal prosecutors, that's a kind of the bread and butter kind of charge. But in our office, we again take a skeptical eye about that. We don't always seek prison time purely because someone has a firearm and previously has a felon. We don't always prosecute it. And so there's a huge amount of discretion that goes into that question. Some of the most critical elements are proximity to recent violent conduct, of course, proximity to large drug trafficking operations with the clear intent to perhaps use that firearm. But essentially, we don't immediately jump to the conclusion that such a charge requires incarceration. And again, we know that different communities are more exposed to policing. And so if you have this kind of compounding effect, it can become a situation where there are unfairnesses in the way that particular status offense is applied. DA Woodall alluded to this as well. I think mandatory minimums are a critical area for us to think about. I know that my boss, Misty Berry, alluded to James Foreman's Locking Up Our Own, which is a wonderful and detailed narrative about mandatory minimums as they developed in Washington, D.C. I'd put a plug in for that. And it raises some really difficult questions around race and the way that these laws get passed. But ultimately, on my team, there are very difficult decisions being made all the time. If someone has over 4 grams of heroin, the law allows us to immediately seek 70 months of incarceration. And having spoken with different groups locally, such as Harm Reduction Coalition in North Carolina and others, we don't always believe that serves justice, which means that we are exercising our discretion in a very broad way to determine whether someone should really go to prison for 6 years for that amount of heroin. Over an ounce, of course, carries punishments of upwards of 18 years. We all know that across the state, not everyone who has an ounce of heroin is going to prison for approximately 2 decades. And yet the way that we are using our discretion from jurisdiction to jurisdiction varies wildly, to be frank. And I think that we as prosecutors need to own that and be transparent about how we're making those decisions, where we are creating those benchmarks. Again, so there's different ways, and Jamie Markham at the School of Government has written about this, and every prosecutor is familiar with different ways to avoid those harsh mandatory minimums. There are lesser included for attempt that put you back on the structured sentencing grid. There are lesser felonies that can be charged, Class H or Class G felonies. But again, there's this vast terrain that can be inhabited by these charges. And the DA has a large part to do with how that is inhabited. Related to the mandatory minimums are proximity to school, childcare, or parks, the enhancement that makes it a Class E felony. The Sentencing Project has written extensively about that and documented it from state to state. I'm happy to share that material further, but we rarely use that enhancement unless we really think there's a true danger to children, where there's a true sense that this drug activity is endangering children, because it's been well documented that these kinds of enhancements can have troubling and disparate impacts on populations of color, and that they're specifically prone in urban areas to be charged with some regularity in a way that's not fair. On a lesser note, I think this is the kind of proverbial low-hanging fruit, but we know from recent ACLU reports and others, it's common knowledge that Blacks are almost 4 times as likely to be charged as whites or arrested for marijuana, despite roughly equal rates of use. So in Durham, we make that a very distinct low law enforcement priority. We frequently decline to prosecute those charges when they come. I can speak frankly, in my experience in district court, virtually everyone who walks in the door with a marijuana charge is a young Black male. And so we know that there are unfairnesses in the way that that charge can come about. And that not necessarily that has to do with racial animus. It can have to do simply with encounters with police officers and the way that they're likely to encounter law enforcement. But we essentially think that's not a good use of our time, given scarce resources. And we do prosecute it in certain circumstances. For example, if there's clear proximity to children or there's an association with impaired driving. But frequently our default is to decline to prosecute that. And related to that, we reserve drug court resources for those who are high risk and high needs. So this was a learning curve for me as well, in terms of understanding how drug court should be utilized. And I think it's a subject of controversy. I know that the Chief Justice has made drug court a big priority of hers. I would note that in Durham, we try to use it when there's extensive property crime, when there's a real spillover effect, where substance use disorder is causing problems to victims. And we don't tend to use scarce penal resources for those who are suffering from addiction but who don't have crimes that are involving victims. And we frequently tend to refer people to treatment or urge people to engage in treatment. And then even when it comes to serious and dangerous drugs such as cocaine and heroin, we frequently want to see those individuals engage with treatment and treat it more like a public health issue rather than a penal response. And finally, I just wanted to note the important duties that we have under Giglio. I think this is a key area for us to think about. I think that the way Giglio Material is handled statewide and nationwide, for that matter, there's great articles written about this, it is incredibly different, right? It's not consistent from jurisdiction to jurisdiction. And we continue to improve on our policy in Durham and try to develop this. But I would say that it's important to have a policy. These are difficult, complex issues that can involve personal records and constitutional duties and sensitive material. But to attempt to actually articulate a policy is important. And we've looked to the Conference of District Attorneys for guidance here. We've also looked to Charlotte Mecklenburg, who have been innovators in this area, and we've received assistance in different ways. But I think it's very important to have a policy and to have a committee that is dealing with these issues, because when a prosecutor is in the middle of it and is working with police officers and about to call them to the stand, that's not really the best time for neutral decision-making. So a committee can buffer some of that conflict. And it's critical that we keep a record, that the information is organized so that it doesn't just end up buried in a file or lost somewhere. Very simply in Durham, we have a spreadsheet where we can track kind of the bare bones contours of what may be Giglio material. And that is, ADAs are able to use that spreadsheet to alert to potential issues. And then the committee can look further when appropriate. So we know that there are constitutional obligations as well as ethical obligations to do a reasonably diligent inquiry into potential Giglio material, which of course is material that may bear on the honesty or impeachment material relevant to the state's witnesses. So in conclusion, I think that the takeaways that I think are relevant are that data is key to understanding how biases are infecting the use of prosecutorial discretion. And we have to look at ourselves with scrutiny and do the difficult work to try to gather that data and expose it to the public. Secondly, that these sentencing enhancements and plea bargaining patterns should be monitored, hopefully by independent researchers, but at the very least supervisors, to try to ensure that there's consistency and attention to disparities, and to be aware of the way that racial disparities are compounded. And finally, I'd say that Giglio policies have to have structure and consistency. Thank you very much for your time.
Thank you very much. Does anybody have a quick question? All righty then, well, we will keep on going. So Representative Maury, we have another presentation.
Okay, thank you. Danny, thanks. That was really terrific. And if your PowerPoint hasn't been shared, if it can be shared to our shared documents, really appreciate it. The Giglio is one thing we haven't talked about yet, so thanks for adding that in. I think that's really important. So we're gonna shift a little bit now, and I know we're getting a lot of information today, but I think it's gonna be a great foundation for our discussion. If it can't be today, it'll be our next meeting. But to look at what both Danny and Jim have alluded to, the overcriminalization. What are we doing with our statutes? What are we doing with city ordinances? What can be done to address these racial inequities, especially with some of the lower level offenses so many people get caught up into? So first, I'd like to introduce Assistant Attorney General Amisha Cooper, who I had the pleasure of working with in Durham. She was a fabulous prosecutor. She did great work in our juvenile court, district, and superior courts. She's now with the Attorney General's office and is doing a study and really looking into what are we doing on overcriminalization. So Amisha, the floor is yours. Thank you.
Thank you, Judge Morey, and it's an honor to be before you all. I've written down my remarks so as to be respectful of everyone's time. I was introduced to the criminal justice system after I applied to be an intern with the Orange County District Attorney's Office. Mr. Woodall and his knowledgeable staff showed me the ropes and helped me to develop my skills as a prosecutor for 2 summers. And for 5 years, I had the honor of serving my beloved Bull City community as an assistant district attorney. Over those 5 years, I worked my way through the ranks, from traffic and district court to juvenile delinquency court to prosecuting felony property crimes and then felony domestic violence offenses. In my capacity as an assistant district attorney, I witnessed my neighbors, church members, classmates, and family friends become entangled in the criminal justice system for behaviors that pose little or no harm to the community at whole. With our overcriminalization project, we aim to assist the task force in identifying nonviolent offenses that criminalize conduct that the criminal justice system is not equipped to address. Our thought is that the consequence of eliminating these offenses will be a meaningful decrease in the frequency of interaction between law enforcement and the public, particularly Black and Brown members of the public. We can do this by taking a look at offenses that prosecutors routinely reduce to lesser offenses or dismiss after compliance with an unofficial condition, such as a repayment to make a victim whole. Offenses like failure to return rental property, which turns the breach of a contract, which is a civil matter, into a criminal offense. I won't address the predatory nature of some of these contracts, but I know that some of you know what I'm talking about. Other offenses are window tint violations, expired registration, or expired driver's license. Another area that can be examined is local ordinances. I'm really excited that we get to hear from Professor Smith, who's done so much work in this area and whose publications we have relied upon. Some of the conduct that is criminalized by ordinances includes sleeping in public, panhandling or begging for money, urinating in public, loitering, or failing to keep one's dwelling up to city or county standards. The truth is that many of these offenses criminalize poverty. And the final area that we propose should be examined and has been mentioned already, several community stakeholders have voiced their concern and interest in, is marijuana. Steve Mange, who's our Senior Policy and Strategy Counsel here at DOJ, has done a lot of research in this regard. And he's outlined 3 ways forward that have been utilized by other states as options for you to consider. They include legalizing recreational cannabis, legalizing medical cannabis, or decriminalizing cannabis. Now, each of these options come with their own set of pros and cons. Several states have legalized recreational legalizing recreational cannabis will bring about the need for a comprehensive plan to regulate it. More than 30 states have legalized medical cannabis, which authorizes doctors to provide or prescribe cannabis for a variety of medical conditions. And several states have decriminalized cannabis in some fashion. For North Carolina, that could mean eliminating criminal penalties for possession, use, and sale of limited amounts of marijuana, or making the penalty for possession and or use closer to that of an infraction that would be punishable by a fine. I hope that this summary of our over-criminalization project has been helpful. This is such a pivotal time, and the work that we do with this task force has the potential to change reality and outcomes for generations to come in a way that has never been done.
Thank you very much, Amicia. Any questions right off? Burning question that you really need to ask or like to ask?
And Amicia, you're doing a report. The report should be finished later this year. Is that right?
That's correct.
Okay, we'll be eager to see it and hope it becomes a part of the information for us.
Yes.
Thank you so much.
You're welcome. Thank you.
And then we have our final speaker, Representative Maury.
Okay, and to wrap us up and bring us the heavy duty stuff, Professor Jesse Smith, who talked to our original task force on our first meeting, was extremely helpful. But Jesse is a distinguished professor of law at the UNC School of Government. She has done almost every task force that you can imagine in North Carolina pertaining to the criminal justice system. Most importantly now, she's the director of the Criminal Justice Innovation Lab. And she's going to talk about that and really take what Amicia said and take us a deep dive further on what can this task force, this working group, recommend for overcriminalization. So thank you, Professor Smith. Really appreciate your being here.
Sure. Thanks for having me. Good afternoon, everybody. So Representative Morey asked me to speak about three things with you this afternoon. First, at a recent task force meeting, I presented some big picture data about the number and types of criminal charges that we make in North Carolina. We're going to do a recap and look a little bit harder at that, focusing, as she asked me to do, on some areas that you may want to examine for either decriminalization or potentially looking at reclassification of offenses. She also asked me to touch on the issue of criminal charging, citation versus arrest, summons versus warrant, because how an offense is charged has a lot of significant impact. And third, she asked me to talk a little bit about what we know and what we don't know about how all of those things, how racial issues relate to all of those things. So I'm going to go ahead and do a screen share. Are you now seeing my PowerPoint screen? Yes. Okay, great. Let me just make a little adjustment here. Okay, so this slide should look familiar because this is one that I used at the larger task force meeting. And to recap, here's some numbers that this derives or continues a conversation from where Jim Woodall started and Danny Spiegel mentioned and Amisha also spoke about. But in 2019, we had about 1.9 million total criminal charges. The vast majority of them, 1.6 million of those charges, were for misdemeanors. And what I want to do is I want to focus in a little bit more on those misdemeanor charges because they make up the bulk of the system. And as I mentioned when we spoke last time, of misdemeanor charges, only 6.66% of them are for violent offenses. And when we did this analysis at my lab, I'll tell you, we used a very aggressive tool for categorizing things as violent. But what that means is that 93% of those 1.6 million misdemeanor charges are nonviolent. So I often say that our criminal justice system is largely a nonviolent misdemeanor system. And those are the numbers that support that statement. It's not what's in the newspaper or on the TV news, but that's the business of our criminal justice system. Importantly, of those 1.6 million misdemeanor charges, 1 million of them were traffic related. DA Woodall spoke earlier about the criminalization of our traffic code. So not only are we largely a nonviolent misdemeanor system, a huge portion of those misdemeanor charges, in fact, are traffic offenses. So if you as a task force are going for the biggest impact in terms of addressing criminalization, one place to start is with the largest categories of offenses. Where are the big numbers? And they're misdemeanors and they're traffic offenses. So what are the traffic offenses that make up the bulk of those misdemeanors? We have a full report on this. I believe it's been put in your document bank. I'll show you where you can find it online. But this is a listing of the most commonly charged nonviolent, non-DWI, let's just take DWI off the table. So nonviolent, non-DWI traffic offenses in 2019. Here they are. As you can see, there are 4 charges here that make up a lot of the numbers. Speeding at almost 300,000 charges, expired registration, 208,000. Driving while license revoked, importantly, this is a non-impaired revocation. So these could be for failure to pay tort costs and fines, and also no operator's license. And we've listed some other of the most commonly charged non-DWI traffic offenses. Now, to be clear, I am not advocating that this group do anything with respect to these or any other offenses. I'm simply responding to the request to help you understand where the bulk of the charges are that make up North Carolina's criminal justice system, where the bulk of the contact is that law enforcement is having with individuals in North Carolina. When you look at this list clearly, some people are going to look at this and see things that they believe, in fact, are dangerous and should be made criminal. Perhaps one of you might see reckless driving to endanger as something. But there are other offenses, and some of them have already been mentioned, that folks disagree with them being characterized as criminal. Window tinting, I believe, was one. It's listed here. You can see how many charges, 12,000, over 12,000 charges annually. But there are others on these lists. And this is, again, one place you may want to look for big impact. Because, and I say that not because I'm advocating it, but that's where the numbers are. The numbers are in the misdemeanors and the numbers are in traffic offenses. Because of those total 1.6 million misdemeanors, 1 million of them are traffic offenses. Another place that you might want to take a deeper dive into is the other misdemeanors that aren't violent, they're not DWI. What's in that group? Well, here's the list of the most common ones that were charged in 2019. Misdemeanor larceny tops this list, as you can see, with 44,000, but that number pales in comparison with the traffic offenses. This is what we just looked at. You know, you have to go pretty far down the list, you know, of the top offenses to get to that level. So misdemeanor larceny is the most commonly charged non-violent, non-traffic misdemeanor offense in 2019. But the next 3, and again, this is another issue that's already been raised, are drug offenses: possession of drug paraphernalia, marijuana possession, and possession of marijuana paraphernalia. And you can see some of the other offenses that are listed here. And again, the reason why I'm presenting this is if you're going for impact, you go where the numbers are. So we looked at the numbers, the most commonly charged traffic offenses, except DWI. And now we're looking at the nonviolent misdemeanor offenses. And you can see the numbers drop off pretty quickly. So if you're looking for impact, that's one thing to look at. But Representative Morey also asked me to talk about the issue of ordinance charges. Now, under North Carolina law, the General Assembly has by statute delegated authority for cities and towns and actually metropolitan sewerage districts to create crimes by ordinances. And they do that. They prescribe certain conduct in an ordinance, and it is a misdemeanor under North Carolina law. In North Carolina, we have over 10,000, at least over a minimum of 10,000 a year of ordinance charges. So it's a small number in terms of the slice of the pie. So in this picture here, it's that little gray slice of the pie. I see that's a little blurry, sorry. On the left-hand side, in 2019, it was about 11,000 charges. But here's why people are interested in ordinance charges. We did an analysis of ordinance charges back in 2018. And here's a list. And in your document bank, you've got a couple of reports that have all this data in them. So don't worry about taking notes. We did an analysis of the 2018 data. And we kind of ranked the most commonly charged ordinance crimes as well as we could identify them based on the AOC data. And the single most commonly charged identifiable ordinance crime coming in at over 1,600 charges is begging. There are other charges on this list that are associated with poverty and homelessness. Urinating in public, sleeping in a public place, trespass, or sleeping in a park. Even though the ordinance crimes don't make up a huge piece of the pie, there are many folks that have raised questions about whether it's appropriate to deal with conduct related to poverty and homelessness through the criminal justice system. And they appropriately note, as has already been mentioned, that the criminal justice system is not very effective in dealing with these issues. So John, the disabled veteran who's experiencing homelessness and is begging outside the Food Lion, when he is arrested for begging, the most common ordinance charge, and is convicted and is not going to get any time for that sentence because of the offense level and the punishment chart, and goes back into his community, he's still homeless. He still has his other issues. He's still poor, and he's likely to continue the same behavior. The criminal justice system didn't do anything, didn't provide him any services to get at the root cause of that particular behavior. And so John, and we see this in multiple communities, cycles through the criminal justice system until he cycles through enough that now he has enough prior record level points that he can actually get some active time. He's no better when he came out, and a lot of people note he's actually worse because now he has a criminal record, and any hope that perhaps a faith-based organization or a local nonprofit had to get him into public housing or a job, he now has a criminal record, which can be a barrier to that. Folks also look at ordinance crimes and they see other things on this list, and it has them scratching their heads about whether these are things that warrant turning on the expensive, punitive criminal justice system. And you can see some of them here. Leash law violations, no city dog tags. If they're made criminal by the local ordinance, they're criminal by the local ordinance, and they result in entry into the criminal justice system. Those are just some of the questions that people are asking about ordinance crimes. Again, not because they're a huge piece of the misdemeanor pie, but because of the equity issues and the efficiency questions that are wrapped up in that type of charging. Turning to felonies, and fire out questions as you have them. I can't see the chat box, but unmute yourself and fire them out if you have them, please.
Yes, it's Josh. My question is, like, on all the traffic stuff, like, what is the alternative? because we don't want people speeding. We don't want people driving without insurance or without registration or being unlicensed. So
Yeah, thank
there's
you.
administrative processes through DMV, but then what's the sanction? Ultimately, we don't want to send them to jail, but we also don't want to take away their driver's license. So what ultimately do we have as a deterrent?
Well, there's a lot of conduct that we deal with through the infraction system, the non-criminal infraction system. And I sort of think of that as part of the regulatory machinery of how we deal with things. So that is an option that can be used. I mean, there's always the option of just saying, we're just not going to regulate certain behavior, whether it's I would hesitate to give some examples now, but that's one option. But, you know, again, another option is to treat it as a non-criminal infraction, as we do with other kinds of behaviors. The cautionary note that I would make, and it sometimes comes up, and in fact has actually happened, is that sometimes some of these lower level misdemeanors are simply made into their punishment classification is lower down to a class 3 misdemeanor, which is some people have described as sort of the worst of both worlds, because it remains a crime and then it also removes the person's entitlement to counsel, because for most of those offenses they wouldn't get any active time. So people pick up criminal records, but they don't have a right to counsel. So those are the sort of the three options that have been considered and or used within North Carolina: decriminalizing, reclassifying. Yeah. Did I answer that question?
Yeah.
You're not satisfied.
Well, because, okay, so then you do an infraction, but then they don't have the ability to pay the infraction. And so then they don't pay the infraction. And then what happens at that point?
Yeah. You know, you're raising a really good question, where the sort of the rubber meets the road in a lot of areas of criminal justice, where issues of ability to pay smash up against the criminal justice system. You know, for example, you know, if you don't want to put people in prison for certain lower level crimes, you want to create an incentive with a fine. Well, what if they can't pay? What, you know, what that does that mean that anybody who can't pay, there's no sanction to put on them? And so people sometimes talk about other options, like maybe there's a community service option, but that has its own set of roadblocks. Do those people have the ability to get to and perform community service, transportation? Can they get off of work? Those type of things. It is a really, really difficult question to answer. And I hear a lot of people who are very interested in decriminalizing conduct, but really struggle with precisely what you mentioned, which is the conduct. Some of the conduct is stuff that we want to discourage in society. And how do we do that in an equitable manner? Now, some folks would say that for a bit of this behavior, and I was about to transition to this in a moment, like behavior related to drug offenses, that you could potentially address it by getting at root causes of behavior with community services, such as effective drug treatment programs, so that people don't enter the criminal justice system in the first place. But that requires a level of commitment and community support with a sort of longer tail on seeing your positive outcomes than some people are willing to wait for. But that, I would think, has got to be a part of the conversation.
Thanks.
It's not
Mr. Attorney General, I think what Professor Smith's comments, I mean, looking at all these different types of charges that folks have, whether it's ordinances or these various low-level property crimes, obviously it's going to be tough not to have sanctions when folks are speeding on the road, because you can hurt somebody. But when we're prosecuting things like resisting a public officer, especially like a standalone resist or a second-degree trespass, I mean, why do we choose to continue to prosecute or charge folks with those types of criminal charges, or like we talked about the ordinance? I think that's where our task force can do a lot more work on affecting change, and especially looking at our fines and fees, because even if we do like you said, Professor, if we do get the infractions, now look, if you can't pay your infraction, you still lose your driver's license at the end of the day. And I think that's why it's great, because the task force, we did make a recommendation, our second meeting, we're looking at ability to pay determinations to be made by our courts. I mean, that's a positive step. It's a bill that I sponsored in the North Carolina Senate, so folks can keep their driver's license. It's a jobs bill, essentially, an equity issue. But I think we can focus on different things that we need to do to make it much more equitable and just. So thanks for those breakdowns, Professor.
Yeah. Yeah, it's a great question. I think it's one you're going to continue to confront as you look at overcriminalization, is how do you address the behavior in the community in a way that's fair and equitable. On the issue of felony charges, I mentioned last time when we spoke that of those 300,000 felonies, only 16.4% of them were for violent offenses. And there are two points I want to make about felonies. Here's a list of the most commonly charged non-violent felonies. And I want you to look at obtaining property by false pretenses. It tops the list. I can't tell you this as a matter of fact, but I'm willing to bet some good money that most of these are worthless check charges. Because under North Carolina law, when you pass a worthless check, you can be charged with a misdemeanor offense, worthless check, or that can also support a charge and conviction of obtaining property by false pretenses, a felony. And I mention this one because this is one that I hear folks raise over and over as a potential reclassification offense, that perhaps it's not appropriate for any worthless check of any amount for the prosecutor to have the discretion, going back to what Jim Woodall was talking about, to charge that same $500 worthless check as either a misdemeanor or a felony. The other thing is that a third of these felonies are drug offenses. And we were just talking about this as an issue. Here are the common drug felonies that are charged. Why do I mention this list? Again, if you decide as a policy matter that it makes sense to deal with societal issues outside the criminal justice system, as we saw with the misdemeanor numbers, and as you can see here with the number of charges, substance use and behavior related to substance use makes up a lot of the justice system. Representative Morey also asked me to speak with you a little bit about citation in lieu of arrest. This is an issue that's gotten a lot of attention as people have begun to understand the significant impact on individuals and communities of how charges are actually initiated. We just saw how many charges we initiate, but the impact is really huge. I mean, in terms of liberty interests, for example, there's a huge difference between whether the officer issues you a citation, as he's doing here, versus physically arrests you by taking you into custody. We've seen newspaper story after newspaper story about arrests for low-level offenses that escalate into violence or sometimes death, not only for the individual that's the suspect of the behavior, but sometimes for the officers. There are other issues besides those that are wrapped up on this. Arrests frequently lead to imposition of secured bonds, and those can lead to wealth-based as opposed to risk-based detention, sometimes for really long periods of time. And the 21st Century Task Force on Policing recommends that officers engage in least harm resolutions, and that includes issuing citations instead of arrests in appropriate cases. My lab has looked at the issue of how often they exercise their discretion to issue charges by citation versus arrest, and they do it a lot. The NCAOC supplied us with data and we looked at it and found statewide officers charged almost 88% of highest charged misdemeanor cases by citation, as opposed to making an arrest. Now, there is huge variation at the county level though, huge variation. In Transylvania County, only 70% of the cases, highest charged misdemeanor cases, are initiated by citation, which means that 30% of them result in arrests. In Anson County, 97%. I don't know why, but there's a big variation across, and the numbers are huge. In 2018, there were 945,000 cases initiated by citation. So even a very small change in percentage could have a huge impact on how people are affected by the criminal justice system. It's a huge.
Jesse, if you, like Chief Holtzman from Greenville, who used to be in Maryland, said there's actually a state law there that says if you have a certain class of misdemeanor, law enforcement doesn't even have the discretion to arrest. It has to be a citation. Is this anything you're familiar with, to sort of just take it off their shoulders and leave it for the higher level misdemeanors?
Yeah, so there's actually, I'm happy to supply the task force with it. There's some research that the International Association of Chiefs of Police has done about the ability and discretion of officers to decide whether to charge by citation or arrest, and it varies. It varies at the state level, and more often, though, you sometimes see local policies that are in place. Charleston, South Carolina, for example, has one. In North Carolina, of course, in almost all instances, law enforcement has a choice. It need not be thus. It could be changed. You all could decide to make a policy recommendation that, for example, for certain low-level offenses, certain circumstances, that a citation is the default. And I'll tell you, there's a lot of interest in this issue from law enforcement. And in fact, my lab has a large project ongoing right now with the North Carolina Association of Chiefs of Police. We have worked with them and developed a model citation in lieu of arrest policy. It was offered to police departments across North Carolina. They applied to participate as pilot sites. And on Friday, the team will be picking the pilot sites, and we'll be tracking them. They'll go live November 1st, implementing the new model policy. I'm happy to share it with the task force if it's of interest. And we're going to be tracking them, looking at how the use of citations changed, how court appearance rates changed, how criminal activity rates changed, officer time savings, jail usage. And we're going to compare all that to police departments that didn't implement the policy. So that's one project that's ongoing, and we'll be issuing reports every 6 months on that project. We're really excited about that potentially being an evidence-based model for North Carolina. It need not be the model. There are other approaches, such as the one that Attorney General Stein mentioned, which just creates blanket rules for certain classes of offenses.
And Jesse, are you going to track that with racial bias, racial inequity?
Yes, absolutely. Absolutely. There are pretty vigorous metrics in there to track it by impact, because of course, one thing you don't want to happen is see a higher rate of citation issuance, but see expanded racial disparities where, for example, officers are more willing to issue citations for people who are white than those who are non-white.
Professor Smith, since you said 88% is the highest charge of misdemeanors initiated by citation, do you have a breakdown for the remaining percentage? What are those offenses that officers are primarily arresting folks for?
I don't know. I don't have the answer to that question. We, of course, will have it as part of this project for the pilot sites, but that information actually is attainable. And we have a database that we arguably could look at. And as a matter of fact, we probably could look at it and we could say, for example, looking at class 3 misdemeanors at the statewide, and we do it at the county level as well, what's the incidence of citation versus arrest for class 3 misdemeanors, class 2 misdemeanors, A1s, et cetera. That information would be available in the ACES system. So we could, I don't have it, but we could produce it.
Thank you.
The other issue, and it's very much related to what we just talked about, is summons versus a warrant. Representative Mori asked me to speak about this. The reason people are interested in this largely parallel the reason they're interested in citation versus arrest, because the summons, like the citation, is a piece of paper that says, come show up in court and answer the charges. A warrant for arrest, like the officer's warrantless arrest, results in the deprivation of liberty, the determination of pretrial conditions, which, as we've talked about, they're most likely going to be a bond, and then all the consequences that flow from that. In this area, while citations are used a lot by officers in misdemeanor charges, is misdemeanor cases, criminal summonses, not so much by magistrates. We looked at that at the state level. And in 2018, we found they used a summons to charge highest charge misdemeanor charges in only 32.9% of cases. In all the other misdemeanor cases, it was a warrant. And remember, just keep in mind, of all those misdemeanor charges, only 6.66% are violent. And yet the vast majority of them are resulting at the magistrate stage in charging by issuance of a warrant, which is the deprivation of liberty, the contact with the officer, the secured bond determination, and all the other things that we've talked about. Where you live, though, really matters. The numbers vary even more widely than with citations. In Yancey County, only 8.7% of highest charge misdemeanor cases are initiated by a summons. In Greene, it's 60.9%. So where you live, we have a uniform court system, but where you live in this respect really matters in terms of defining that initial involvement with the criminal justice system. The final issue that Representative Morey asked me to cover was this. She said, well, what can you tell us about the issues we talked about, the criminal charging and the citation and the summons by race? And unfortunately, the answer is today, not a lot. The data that I presented to you is either public data that the AOC has put out on its webpage, or they provided to us in connection with other projects. It did not include any racial information. That information, although some question the accuracy of it, it is in the court system. So in theory, one could look at it. I will tell you, Stan, this is a critical issue at the lab. We've made a big investment of time and energy and money into putting court system, the entirety of the ACES system, into a searchable database. And we are in short order going to be able to refine all those analyses that I just presented to you with racial information in them. But those are the questions that she asked me to address. All of the reports, the data spreadsheets, we make all of our spreadsheets available for free. They're all available online at our on our website. And if you have any trouble finding them, reach out and I'll make sure that you get them. I'm happy to take questions or just sit here and be quiet in case any arise.
Jesse,
Smith.
thanks. Just one question at the very end. You said all this data is public information and you've had to get a huge download dump, but the AOC has the racial data. Is that correct? And we just need to access it?
Well, so I'm not familiar with whether there are a couple of different systems. There are the two systems would be the NC Aware system, and then there's the ACES system, the Automated Criminal Infraction System. The ACES system for sure has racial data in it because we have gotten that through public information request, and it's in there. Some people question the accuracy of the racial information that's in there, but it is in the court system records, and so that is the next step in all our analysis now, is to parse it out that way. But yes, it's in the court system data.
But you weren't able to get it directly. You had to get a huge.
So yeah, so there are different systems. So what we currently have is a base of the ACES system. And that does have racial information. There's other reporting systems, for example, on issuance of secured bonds. That comes from the NC Aware system. We don't have access to any of that information.
Well, would that be a recommendation that we might consider, the better access to that data and the racial information?
That's certainly something for the task force to consider. And as you move forward in your work, we're certainly happy to support you in any way that we can with data analysis.
Professor Smith, you said that despite the unified court system that we do have across the state, you talked about the significant difference county by county. Can you speak to why you think that might be?
That's a really good question. So we've looked at a lot of different criminal justice metrics. We've looked at charging, we've looked at disposition times, that of secured bonds versus other forms of release. We've looked at citation, we've looked at summons. It can be really challenging. In some of these in some areas, we see a direct connection between the numbers and local reform initiatives. For example, Haywood and Jackson County embarked on a major bail reform project in 2019. And in that year, they had the lowest percentage of incidents of secured bonds, for example, in that year. So sometimes we see really clear correlations. We've tried to do different cuts and understand these numbers. They're not understandable to us based on the offenses charged. So I've gone to some communities and they've said, well, maybe the reason we have more arrests than issuance of citations or summonses is because we're seeing more domestic violence cases or really serious misdemeanors, but we have all the information at the county level and we've looked at it and we've provided it for them. And as a matter of fact, we're actually producing now county level snapshots for all 100 counties so that they can actually see. And I don't know if Jim Woodall, you've seen it yet, but you're shaking your head because I sent it to Kate Fenhagen. We beta tested it actually in Orange County and a couple other counties so that the counties can actually see how many misdemeanors did they charge, what percentage are violent versus non-violent, what are the most common ones. And we don't see a correlation between the types of crimes that are being charged and some of the we don't see the types of correlations we might expect.
Okay. So more reasons for our task force in the state legislature to essentially create a baseline for the whole state to help unify these disparities to make them a lot better county by county, I'd assume.
I'm sure that's something that you all will be talking about.
Thank you, Professor Smith.
Representative Maury, we've got about
I have a question.
about 3 minutes. Go ahead with your question, please.
My question is, and I appreciate you bringing that up, Representative Muhammad. One of the statement was made. They compared Yancey County with Greene County.
Yancey.
Knowing it, Yancey and Greene. My question would be, I know Greene is a pretty large populated county of brown people, black and brown people. Would there be, you think there's any type of correlation between the population of each of those counties versus whether it's low, I said, what, Yancey County?
Well, in that instance, I was just taking the absolute lowest county in terms of use of summonses, which was Yancey, and comparing it to Greene County, which actually makes the highest use of criminal summons.
Right, Greene is has a larger population of black and brown people. That's what I was looking at. Basically, looking at the different counties and comparing counties. There's an underline there that we may have to take a look at, and that would determine whether you have a high percentage or a low percentage, vice versa. Thank you.
Yeah, that would be something that would be really easy for us to do. We have all the demographic data already compiled for every single county. We also have the counties sort of tiered by urbanicity, so we could break it down that way. We could look at your rural versus the metros. There's lots of ways that we could look at it that may be of interest to you.
All right.
This is Anita. If I can just make an observation, I know you're running out of time, but I do think on the decriminalization issue that we really do need to understand what the disparate racial impact because a big picture, I think our mission is to end those disparate outcomes. And so maybe the best way to end the disparate, let's assume data shows, as Danny told us, the only people being charged with misdemeanor possession of marijuana are African American, then maybe decriminalization is the best way to stop that practice. But I don't know, I sort of feel like the bigger enterprise of decriminalization, that we want to be taking we want to be looking at that through a racial lens. On the question of data, Emily Mehta from the AOC is on the data team here. I talked to her yesterday, and so I think there's still she's not clear what racial data AOC might have. She's very clear that all the data AOC has is public data and they will make it available. So I think we need to get a little more clarity on what the data problems are. I totally appreciate that getting the right data is really crucial and important, but I just wanted to make clear I've been trying to work through that with AOC.
All right. Next steps, Representative Maury.
Okay, well, next steps to be done in about 15 seconds. Today was a lot of information, and I can't thank all of you enough, because I think it was really helpful to give us our foundation. This discussion probably we need to have at our next meeting. The task force meets next Friday on the 28th. So right now, our job is to present to the task force the work we're doing, any recommendations we're making. I don't know if our working group has any time before the task force on Friday to meet again, to discuss what we heard today, to see if we could come up with any preliminary recommendations. That may not be possible. I just know we still have a lot to do. I think we covered a lot of ground today. Does anyone have any thoughts next Wednesday on August 26th? Does anybody have availability of an hour, say from 4 to 5? Or if we can't do that, I sure understand. I just want to keep us moving, and with all the rich information today, to see if the working group can perhaps come up with a few preliminary recommendations that we might present to the task force next Friday.
I'm available.
Yeah, Representative Maury, I can be available.
I'm available.
Yeah, me too.
If I have permission then from the bearer bosses of Karen, Natalia, Ellen, can we add a 1-hour task force meeting next Wednesday, August 26th from 4 to 5 on a Zoom call?
Yes, we will do that and send out an invite.
Absolutely, yes.
And I hope that's all right. Task force chairs, Justice Earls and Attorney General. I think this group wants to work and tackle some things.
Great.
Representative Maury, would it be okay to so some of our speakers that are here, like Danny and the Professor, to potentially join us to help us guide in that decision-making process? Or
the red carpet is rolled out for them to join us, and Amisha to enter into. We'll try and absorb what we learned today. Meet back next Wednesday at 4 o'clock on a Zoom and have the working group talk and then ask questions back to our presenters if we need to.
exactly.
I know Jesse, Danny, Amisha, you all are very busy, but if you can join us, we'd love to have you. And Jim will be here. Does that sound all right? Then we'll be ready for the Friday recommendations. What a great group. Thank you. Sorry, 3 minutes over, but really appreciate it. And we'll see you next Wednesday at 4.
Thank you, Representative Maury.
Thank you.